Okay, we're live.
Right, we are reconvening our morning meeting with Legislative Counsel Michael O'Grady to talk about S-124 and propose, well, actually, what we need to talk about first is what came out of our agriculture committee.
Honestly, very few changes. There's so few that I hadn't even really,
Okay. That's a good place to begin.
there's been some discussion around the seasonal application of manure and the small farm certification, but they weren't changed. There was discussion about changing the definition of waters for the CAFO program to be waters of the United States. That was not changed. There really weren't that many changes.
And you remember were you there when they voted on this bill?
There was a little bit of somebody wasn't there, and I think they held a vote, but I think it was unanimous. But I'm not certain. Steve or
I think it was essentially unanimous with maybe one person missing.
yeah, there was somebody
For
missing.
the record, who you are?
Oh, sorry, Emma Schultz, the Vermont Dairy Producers Alliance. I was just in that committee when they voted.
Yeah, no, that's great. Thanks. Just need to. Emma, thank you. Sorry, did you say it was unanimous?
Yeah,
Um,
except for that one person that wasn't there.
and the other day I actually am looking for the handout I thought I kept, and I handed you a copy of some requested changes, and asked you to respond to them for us.
Sure.
You need something on? Okay.
So this is the handout that you gave me. I'm not sure if it's on your website.
Yes, I guess probably under Jared Carpenter or Scott.
Okay, I think it's under Jared's name. But basically, their recommendations to amend S-124. And I'll just work through them if you want me to. The first is to establish an inspection schedule. Would ensure that ANR fulfills its responsibility under the Clean Water Act to monitor AFOs on an ongoing basis by requiring ANR to conduct AFO inspections at regular intervals, use inspection frequency made familiar to farmers by the Agency of Agriculture inspections. And so currently the Agency of Agriculture is required to inspect large farms, medium farms, and small farms on regular intervals. They're required to do large farms every year, medium farms, no less frequently than every 3 years, and small farms not less frequently than once every 5 years. So what has been proposed is to have a new section added to the ANR CAFO chapter to require ANR to inspect at those same intervals. An LFO would get a large CAFO would get inspection every year, medium CAFO at not less than every 3 years, and a small CAFO would be not less than every 5 years. And then the secretary would be given discretion to inspect at any time. Any CAFO. So that is consistent with inspection requirements that the Agency of Ag has right now. My only question would be capacity at ANR.
Representative Chapin.
So when you say right now, that's what's required, do you mean in statute and for large farms, medium farms, and small farms? So that will continue under the Ag Agency inspection schedule?
So under the Ag Agency, if a farm is determined not to have a discharge that requires a CAFO permit, they would remain with the Agency of Ag and they would still be subject to these inspection requirements, yes.
And that's in statute,
That's in statute.
the required ag practices.
It is specifically required, that term, but frequency in statute.
And for for farms that are AFOs, this would apply, if we added this language, this would apply to all AFOs.
It would apply to all those CAFOs that are in ANR's jurisdiction. You're still gonna have a large farm inspection by the Agency of Agriculture, because remember, they're gonna have dual permits. But right, this would just specify a schedule for ANR to do inspections of the jurisdictional CAFOs.
And if we didn't add this, are we expecting sort of through rulemaking such a schedule to be identified by ANR? Or we would just, it would just.
You're doing it specifically, what is proposed is to add a new statutory section that would require that.
If we added this,
Yes.
what was I trying to say?
You were trying to say if we didn't add it,
Right, if we didn't add it, it would just be at ANR's discretion.
Right, or if they, remember, you're directing them to adopt by rule a CAFO permit, and they could have done it under that. If they had wanted to.
But we didn't require
They didn't require
an inspection schedule under that.
frequency,
rulemaking.
no.
it's like a good thing to add. Representative North.
Isn't that already specifically stated on page 9, line 5 and 6? The secretary can inspect farm permitted under this section at any time, not less than frequently than once per year.
So that is not the CAFO program. That is the Agency of Ag program. So this is saying that once a farm is in the CAFO program that's run by ANR, that it has to get inspection according to a frequency. So for water quality, I think maybe a good example is the MFO. An MFO right now, not less than 3 years by the Agency of Agriculture, but if ANR determines it needs a medium CAFO permit, it no longer needs the MFO permit. It's going to need a medium CAFO permit. But there's no specific frequency for inspection in the bill right now for that medium CAFO. And that's what the language is.
The last time we talked, they ended up having both permits.
A large farm will have both permits, because the large farm permit is not just about water quality. It's about land use, vectors, noise, pest, odor, etc.
But the only hole that we're talking about is whether there's medium farms that are also capable.
Well, it's about frequency. You've given ANR inspection authority. They have ability to inspect. They have ability to go on property. They have the ability to determine any AFO as a CAFO. But you haven't told them how frequently they need to do that. And this would say they would have to do that for a CAFO frequency that's set out in the recommendation.
Frequency of determining whether or not they need to continue to be considered a CAFO because they're discharging.
Well, it's about inspection. It's about if they're compliant, so they've already been determined to have a CAFO permit. And now the agency has to go out for a large CAFO every year to determine if they're complying. For a medium, not less than every 3 years to determine if they're complying. That's what it's really, a compliance inspection, not a jurisdictional inspection. Because they've already become CAFOs, or the jurisdictional determination has been made, and now it's about inspection for compliance.
And the
Understanding where the hole is that we're trying to fill.
So the whole is there's no frequency that's required under the new CAFO subchapter for ANR. If they don't need that ANR permit, there is no hole. There's already an inspection schedule. If they need the ANR permit, there's no inspection schedule in statute. It would be up to ANR to set that inspection schedule. So the question is, do you want to set the inspection schedule for ANR permitted CAFOs?
Representative Chapin.
So I'm interested in setting an inspection schedule potentially for CAFOs. I'm confused about why MFOs and SFOs are listed here. Yes, it's large, so it's large, medium, and number 3 in particular, I'm a little confused by. In what case would have jurisdiction?
You're gonna have to talk to the advocates of why they're having MFO. It may be that they want those to be inspected by A&R to determine if they're jurisdictionally required to get a CAFO permit. But that's more of a policy decision rather than like the administrative working of the A&R CAFO program. And that relates to other recommendations later in their list of recommendations.
Jurisdiction over.
It's about the cooperation between the two agencies about whether or not if the Agency of Agriculture determines that there may be a discharge, do they promptly refer to A&R? The recommendation in this list is that you take away that cooperation, that determination by the Agency of Ag and just say, when the agency the A&R determines that there's a discharge. And so that would mean that A&R's got to go out and determine if there's a discharge. So that is more of a, well, the rest of these are basically, this is kind of like a mechanical thing. The rest of them are pretty policy oriented. And there's arguments on both sides. This is really, hey, do you want to set the mechanics of an inspection frequency schedule? And that's up to you.
Yeah. Jared Carpenter, did you want to comment on this before?
Yeah, so Jared Carpenter, Lake Champlain Committee. Thank you, Madam Chair. No, the thought was, just as Mike was saying, was to have the two agencies on the same inspection schedule so that there's some consistency for farms of large annually, medium every 3 years, small every 5, and it trims it up with the EPA's requirements from the September 6th letter. A&R personnel must inspect all potentially jurisdictional farms to determine if a CAFO permit is required, as well as stating this includes making A&R responsible for conducting routine inspections. So this puts down a schedule for routine inspections that is already in the books, so to speak, for Title VI. It just sort of trims it up for both agencies.
Representative Prickett.
Was this testimony shared with Ag, this testimony here, Chair?
Yes, I did testify to all of
Okay.
these. They only discussed one or two of them. They didn't discuss as a committee all of them, but I did go up and walk them through all the proposals.
Okay. But it came out unanimous. This came out of Ag unanimous. Okay. So I wonder why they felt that wasn't necessary.
Oh, I don't know.
It's in Title 10 and that's our area. They were expected.
They were focusing strictly on Title VI.
All right, let's hit the others.
Okay, recommendation number 2 is to treat the Clean Water Act as the regulatory floor, not the regulatory ceiling. So what does that mean? It means that the program just needs to be, do you want it just to be managed to the Federal Clean Water Act reg requirements? Or do you want to give the Agency of Natural Resources the ability through rulemaking, through their CAFO permit, to be more strict or to have additional requirements than the Federal Water Act? And that's a policy decision. I don't know how the argument for just having it as a ceiling is that's all EPA is requiring. They're just requiring compliance with the Federal Clean Water Act, compliance with the delegated authority. That's really all EPA can require. And why do more than that in order to operate the program and maintain delegation? The other argument is that if you give the agency additional authority and the Clean Water Act is just a floor, the agency will have flexibility to address things based on a state basis. It'll give you, the General Assembly, to require more, that if you think more is necessary to be protective. You know, the state kind of does it both ways for water and wetlands. Our water discharge permits and our wetlands permits are more vigorous or go beyond the federal requirements. But things like our indirect discharge permit program or our underground injection control permit, they're basically the feds requirements. And so it's kind of, which model do you want to use?
Representative Chapin.
When you say for some of those latter examples, that it's basically the same federal guidelines or levels, is our statute saying that it should be the same as the federal, or is our statute putting the federal as a floor, and Vermont just isn't, we haven't made laws that exceed that?
For those last two examples, it's basically comply with PL 92-500, which is a Clean Water Act. And then there's nothing else that's been added for those. Whereas for like wetlands and general discharges, things in addition to that have been added. It's kind of just what you want to do. They both have their arguments for.
Representative Chapin.
This is the one that stands out to me as something that might be worth doing right now, given the uncertainty at the federal level, and just to keep things even keel here in Vermont, to say that it's at least as enables us to know it will be at least as the current federal Clean Water Act. And we can't really put the current we can't sort of, make this retroactive to a certain time. So I personally think this might be one of the most important recommendations to work in.
Can we make it referring to now, Clean Water Act as it is now?
There's actually language in H319 as maybe they've actually passed it. I just sent them the clean copy for them to vote on, which says that if statute or rule has a reference to federal law in Vermont, and that federal law is then altered, that it's the reference that's in the state law is going to continue as if it has not been repealed or amended. So it's normally under the Federal Administrative Procedure Act. It's really hard to amend a rule, a federal rule. It takes years. And similarly in federal legislation, I think you all can characterize Congress however you want to characterize Congress, but it's not quick. But what the federal government, the current administration is proposing is something called the Good Cause Clause of the Administrative Procedure Act. And the Good Cause Clause is basically like emergency rulemaking in Vermont. It's like when there is an exigent need to amend a rule to address some emergency or some other exigency, the federal government, the federal agency doesn't have to go through the normal APA notice and comment process. So it can speed up the adoption or repeal of a rule very significantly. And so there has been a directive to federal agencies to look at their rules and whether or not there's a list of like 10 statutes or 10 court decisions And whether or not though any rule was related to those 10 court decisions, and if they are, to use the good cause clause to repeal those rules. And so one of the court decisions that's referenced is the court decision that repeals or significantly changes the Chevron deference standard. Does everybody know what that is?
You've told us, but you can remind us.
So the Chevron deference is it's based on a case, Chevron was the plaintiff, where there was an argument that an agency didn't have authority to interpret an ambiguous statute to adopt the rule the way that the agency adopted it. And what the Supreme Court said is that agencies, when reading ambiguous language, should have deference in their interpretation of what that ambiguous language means. And if that ambiguous language is relied upon for a rule, then the agency should have deference in what they have adopted. So it has led to significant regulations being upheld as being within an agency's authority, with Chevron deference being largely eliminated. There's a question of what happens to those rules. And normally under the APA, there would be an APA like process where maybe there's litigation to challenge each rule, or maybe each agency reopens the rule to amend it so that it's not based on Chevron deference. What the executive order from Trump says is just use good cause clause to identify rules that are based on Chevron and 9 other cases, to eliminate them, to repeal them or substantially amend them. And, you know, for example, the Clean Air Act regs, many of them are based on Chevron. Chevron was a clean air decision. And so what happens to the 400 references to the Clean Air Act air pollution requirements in our Vermont air pollution control regs? Like, what happens?
Your job.
So, working with ANR, I came up with language with their one of their general counsels, Jordan Gonda, to save those statutes and those rules and those programs if any of the federal rules that they rely upon are repealed. So back to this question. Does it matter if it's a floor or a ceiling? If the Federal Clean Water Act isn't repealed, it may.
So does this grant, so what would this have the function of doing? This proposed change in number 2? Would this allow the Agency of Natural Resources to raise the bar, or do they need to come back to us to do that?
No, it would allow them to change through their rulemaking, through the CAFO permitting, to only be more stringent than the Federal Clean Water Act.
As necessary to administer. Okay, Representative Tagliavia.
Based on this statement you made about working with ANR to preserve the rules or whatever.
I was directed to do that by
Okay.
a member.
But because of that statement and the actions that were taken, why do we even need at least as stringent? Because it sounds like action has already been taken. And it sounds like this would be moot.
So this, it would be, it's a good question. And it's nuanced because that language doesn't moot this point. This language is about how much authority you want to give the Agency of Natural Resources going into the future to provide flexibility in this program. And so that's not related to the Clean Water Act. That's related to what authority you give ANR. If you just said the ceiling is the Clean Water Act and its regulations, then that language comes into effect, that language that I worked with ANR on. Because then you would have to be like, oh, if one of their rules has been repealed under good cause clause, it's still going to remain law in Vermont because of that language in 319. If you do what the advocates are recommending, it doesn't really matter about 319. You've given them, the General Assembly's given them more authority than the Clean Water Act.
But only if they use it. So still the floor is the 319 language.
Yeah.
Yeah.
That's a good point.
But that's a backstop. Representative Fabian.
Just a question. If the energy for the inspections is taken from ag, goes over to ANR, is there a cost study done on the employee? I talked to Secretary Moore. They're pretty tight on FTE. Who's going to do the inspections? And is there going to be a shift of employees from ag to ANR? And who's going to bear the cost?
Well, ANR's already requested employees. I don't know what the current budget agreement, I haven't looked at the conference committee report to see how many have been approved for this program. But I do know that in the EPA corrective action plan the plan that ANR gave to EPA, that they do contemplate adding positions, not just this year, but in the future as well to implement this program. I don't know if that will mean in the future you transfer positions from the Agency of Ag to the Agency of Natural Resources. That's possible.
Representative Pritchard.
So presently, the way it's written, we comply with the Clean Water Act. We give them the authority to go beyond that. What's the limits of that authority?
Well, normally it's what you delegate to them. And generally you're supposed to give them like articulable principles for that. And arguably you've done that in the language. One of the recommendations from the advocates is whenever there's reference to meeting the Federal Clean Water Act, or then adding a reference or meeting the requirements of the Vermont CAPO rules. So you have this provision in here about how they have to adopt rules or do rulemaking to implement the entire program. And so that they would have some significant
Authority.
right.
Yeah, I'm not okay with that.
Representative Sakowicz.
Are there other places in statute where we have environmental rules which are initially based upon federal rules, and we've given an agency the authority to go beyond those rules and
Yes.
like there are, and if so, do we have guidelines in terms of how far they can go, or how much discretion have we given them in the past?
It depends on the program.
But this is bounded by this 50s permit, right? I mean, it's limited to that.
Yeah, this is just a CAFO program. It's just a CAFO program. It would not be beyond the CAFO program.
And it's to meet the requirements of the TMDL under that. Right?
Well, it's not the TMDL that this really relates to. This is more about the delegation that it relates to.
But the water quality goals.
Or the state's water quality program. And, concurrently the water quality goals.
and that it's bounded in this particular area of the, you know, of environmental policy. And what I'm thinking more about is just how, you know, if we have, you know, a federal rule that says, or federal law that says, here's what states have to do, and Vermont wants to go beyond that.
Yeah,
I know there are cases where we have gone beyond that, but what I'm wondering is, when the legislature gives the agency authority to go beyond that, how much discretion do we typically give them in terms of how they do that? Like, what are the sort of the boundaries in terms of what kinds of, you know, how much more strict they can be?
It really depends on the program. I mean, one example is the state hazardous remediation law, which lists all the people that can be responsible for the cleanup of a hazardous waste site. And Vermont, a couple of years ago, added a manufacturer who knew or should have known that their product is going to contribute to the contamination to address PFAS manufacturers. That's not in the federal law. And so you, the General Assembly, set kind of the standard of how that was going to be implemented. But they already had an entire program for how to pursue those people that were potentially liable. You didn't need to like do a lot in that program to just add them and then add how the detail of, because the detail was already there for how they would pursue potentially responsible parties. If you were going to do something like, well, like wetlands is it's kind of a dual authority. The Corps maintains its federal jurisdiction, but the state is much more comprehensive in scope and scale than what the Corps is. So you might actually need a Corps determination as well as a state determination. And then maybe might be a better example, solid waste. So there's many different requirements for management of solid waste at the federal level. It's usually around hazardous waste, or uniform waste, or different types of waste. And Vermont has banned things that the federal law allows, like incineration. Like, you cannot incinerate trash in Vermont, where you can incinerate trash in many places in the United States. And so you gave A&R the ability to do that, and by statute and by rule.
Yeah, but was it narrowly focused, or did A&R come to us and say, we want this?
Again, it depends on the program.
Yeah.
So for years, when you granted rulemaking to them, you just said that the agency can adopt rules under this chapter to implement the requirements of this chapter. And it was determined that everything in the chapter was enough articulable principle for the delegation. But then LCAR was getting uncomfortable with that because it was unclear whether or not some of the agencies, not just A&R, but other agencies, if it was clear what their authority was. So LCAR asked you, the General Assembly, to start providing more articulable principles in and the delegation of authority to an agency. And you have done that with certain programs, and you've not done it with other programs.
Okay. We need to keep moving through this list to get through it.
I guess I go to the next recommendation, which would be recommendation 3, guarantee A&R's independence. I referenced this earlier. I honestly don't understand the argument for the first requested change to eliminate a presumption that contradicts the Clean Water Act. and that interferes with A&R's independent judgment. There is a provision in 6 VSA 4810 that says that farms are presumed to be complying with water quality laws if they're following the RAPs. And there's a reference to that in S-124, and it's in the Title 10 sections where it says the presumption in 6 VSA 4810B that farms in compliance with the RAPs are not discharging is not applicable to any AFO determined to require a KFO permit. And that makes sense because you need a KFO permit if you've got a discharge. So there's no presumption that you're complying with the water quality law if they've already determined you have a discharge. But the advocates have gone on to say that you should just strike that presumption because it's the Agency of Agriculture that is involved in determining whether or not there's a discharge. I don't agree with that. The General Assembly created the presumption. The Agency of Agriculture didn't create the presumption. You said if the RAPs are followed, then there's the presumption of no discharge. And that's kind of says the proposed language frees A&R from presuming based on the Agency of Agriculture's findings that farms do not discharge. It's not the Agency of Agriculture's findings. It's you have created that presumption. Well, the Agency of Ag is involved in determining whether there's a discharge. You gave the presumption. So I don't quite really follow this. I mean, I understand how they don't want the presumption to say we don't want the presumption anymore, but that's again a policy decision. That's not a legal decision. That's a policy decision.
Jared Carpenter.
Jared Carpenter, Lake Champlain Committee. No, the presumption is something that has obviously been a concern of the environmental advocates for, well, since it was drafted for a number of years. But we think in light of the time, in light of the fact that this is a bit more contentious amongst the communities, along with number 4, which also has to do with sort of the dual jurisdiction and the back and forth. There is language in the work group or the study committee or whatever it's called here to discuss this over the summer into the fall. And for number 3 and number 4, that would be probably an appropriate venue and some sort of understanding, decision, something along those lines. It's going to be a multi-year process with this. This bill is a good bill as a first start, but it doesn't need to accomplish everything right now.
Okay.
Should I move on to 4?
Although I think we just heard 4 is also folding into the study.
Yeah, I mean, if that's all you want to do, that's fine with me.
Well, I actually would like your understanding of it.
So currently in 124, oh no, that's currently under existing statute, there's that MOU between the 2 agencies about how they're going to cooperate with each other and how a discharge will be determined and who has responsibility if there's a discharge. And that's being replaced by a document, but there's still language in 124 that if the Agency of Agriculture in reviewing a permit application or doing an inspection determines that there may be a discharge, that they promptly refer that to A&R for A&R's determination of whether there is an actual discharge. The proposal is to strike all that coordination cooperation language and just say prior to approval of a permit and after inspecting a farm, the Secretary of Natural Resources shall issue a written determination regarding whether the applicant has established that there will be no unpermitted discharge. So, and these are applications for a large farm permit or a medium farm permit. So it's basically saying in that application for an Agency of Ag permit, A&R has to make the determination and that there is no initial assessment by the Agency of Ag and then a referral to A&R I mean, that that would take away the cooperation and coordination, and that is a decision for you. Whether or not you want it to just be A&R's decision and not involve, Agency of Ag referring anything to A&R. There is one provision in here that I don't think makes sense.
In this section,
And this recommendation for it is to eliminate the 45 business days shall be deemed approval. Remember the large farm permit is not just a water quality permit. So 45 days is what the farms rely upon in their land use decisions when they're going to expand or not. And if you take away that 45-day period, you're taking away regulatory expectations for the large farms for all of those other things that are unrelated to water quality. And I think this might have more impact than intended.
Representative Austin?
Yep. So my understanding is that the EPA got involved because they wanted to clear up roles and responsibilities between the AOA and the agency, Metro ANR, and that these recommendations align with the EPA's letter that they sent.
That's correct.
Okay, so how much flexibility do we have? And still be able to meet with because we're going to have to do this. So I'm just wondering, is there flexibility or is it?
Yeah, I mean, well, I don't know what EPA will say to any change that you make. So they would have to review again and determine any change. But if you're going to be giving more authority to A&R for permitting, that's more consistent with the delegated authority. But with that said, remember, there's also a document that has to be produced by September 1st of this year that EPA needs to approve that outlines the roles and responsibilities of both agencies. So EPA is going to be involved in approving what the roles and responsibilities are.
I thought in their letter, they were really clear that they wanted the ANR to take responsibility for a majority of these.
Of the permitting, for
Right.
leading the permitting, leading the investigations for jurisdictional permitting,
Right.
yes.
Okay,
But that doesn't mean that the Agency of Agriculture is precluded from participating.
right, but this isn't Vermont doing this, this is us complying with the federal regulation.
Right. Can I go on to recommendation 5?
Yes.
Recommendation 5 is to establish clear permitting requirements. This is just language to me. Currently, it says a large CAFO shall not be required to have a CAFO permit unless one of the following conditions are met. And that's fine. So changing it to a CAFO shall be required to have a CAFO permit if any of the following conditions are met. Doesn't say large CAFO, they're just saying any CAFO. This would change the standard for medium farms under the federal rules. Because of the federal rules for MFOs doesn't have subdivision 3, the precipitation related discharge of manure, litter, or processed wastewater. That's not in accordance with site-specific nutrient management practices. So this would expand the discharge threshold for MFOs from just 1 and 2 to 1, 2, and 3. And then allow for other conditions established by the secretary in the VIPT's CAFO rules. So it's language, but it's also an expansion of jurisdiction over MFO. And there had been discussion, I can't remember in what committee at what point, about having MFOs being subject to subdivision 3 here. And the argument was made that's not required by the Clean Water Act, and therefore it shouldn't be included. And that's going back all the way to the beginning of whether or not you want to include the Clean Water Act as the floor or the ceiling. And that's up to you. And then ensure that S-124 stakeholder process informs relevant decisions. You know, do you want to like recognize that the Agency of Agriculture is going to be involved, and to what extent do you want to recognize that the Agency of Agriculture is going to be involved? And that's kind of really what that language is about. And then recommendation 7, preserve programs to protect water quality. This is related to the emergency exception to the seasonal ban on manure application, and to the requirement that certifiable small farms no longer have to annually certify. And it just says, do not weaken the winter manure spreading prohibition and the small farm certification process. They are unrelated. Both of them are unrelated to EPA's objection and need to come into compliance. They were requests by the Agency of Agriculture. One regarding the small farm certifications, it's a resource issue. Do they really need to annually certify every certifiable small farm? And what does that mean for workload? And then for the seasonal application, there's already an emergency exemption in the RAPs. It's just not really reflected in statute. And what is being proposed, one of the changes that the Agency of Ag made, the Committee on Ag made, is for the seasonal application to be issued according to the criteria in the RAPs. Because the way that it was proposed, it just gave the agency the ability to issue an emergency exemption, and there was no criteria for it. So now it says they can issue the emergency exemption according to the criteria in the RAPs, which is already there. Already have emergency exemption authority, and it's really when there's infrastructure failure or other accident need that's different from the seasonal application. Say your manure pit is about to fail, which does happen. And those are dams. Remember, those are dams. Dam fails, there's a lot of unintended consequence. So that's what the emergency language is about, to reflect something that's already enrolled.
Jared,
And then the last is,
Jared has a comment.
Just really quickly, so House Agriculture did consider 6 and 7. They decided to not make the changes in the LOU language in, and they made the changes that Mike just talked about to 7. And they're both Title 6, so I consider those settled.
and then recommendation 8, protect all state waters. When the bill was originally proposed, it was all state waters, and then there was a change to just waters of the United States for the CAFO program, and then ANR and I believe the Agency of Ag asked that it be switched back to all waters. And then there was a request to change it back to waters of the United States. The Committee on Agriculture decided to just leave it as waters of the state, so all waters. So there's been some indecision on that, and right now it will be all waters.
All right, thank you for this walkthrough of these. Do members have final questions? We need to wrap it up. Michael needs to be out somewhere, and so do we, but go ahead.
I have a jurisdictional question regarding CAFO permitting versus LFO, MFO permitting. Since the CAFO permitting would be under AR, which is essentially, which is a delegation from EPA, would any challenge to a farm, a legal challenge to a farm under a CAFO permit be considered in the jurisdiction of a federal court or a state court?
It's a good question. It can be done either. Honestly, you can, most of them are going to be done in state court in the environmental division, because ANR is going to use its general enforcement authority, which says that they enforce in the environmental division. But somebody can allege in federal district court, maybe the subject matter is more federally related, maybe it's more related to a federal rule than state statute or state rule. And that arguably would give the federal court jurisdiction. Maybe there's diversity in parties, like maybe the person that's bringing the claim is an out-of-state person with a particularized interest in Vermont. That could probably go to federal court. Failure of EPA to comply with its own requirements, that could go to federal court. Because then you do have,
Who makes that jurisdictional decision on any given lawsuit?
it's the rules of federal civil procedure and the state rules of civil procedure.
Is there anything that we could add to S 124 that will guide that? One way or the other, or is that really not, that's.
No, I mean, the courts wouldn't want you to guide them anyway.
Okay,
Um,
so there's already a process set up for guidance.
There's already,
Go either way, kind of depending on the.
yeah, and their rulemaking authority. They have rulemaking authority that the legislature can opine on and constrict. And then they have rulemaking authority that they can't, that the legislature can't. I can't remember if the rules of civil procedure fall which category they fall into. I don't know, but
Michael.
Thank you, Michael. We have shifting gears, and then Michael will be back at 11:30 to talk about stormwater. And Michael, is there an amendment or what other changes that the Ag Committee made? We only found one. I guess it's important for us to know what those are.
I can be more prepared to discuss that. Oh, actually, hold on a second. Yeah, could I come back to be more
Yes,
prepared to?
you just need to know it. Yeah, that's fine.